Hi, Professor. I am here to talk about the case about Ranch LLC versus Taco Bell. Some of the summary of this case is that this is an example of an in-fact contract and civil procedure. Also, Taco Bell used Ranch's ideas from the Psycho Chihuahua, and this is why the plaintiff is suing Taco Bell, claiming for in-play contract, misappropriation, conversion, and unfair competition. In 1995, Shields and Rings formed Ranch LLC, and around this year, they also created a Psycho Chihuahua, which they started advertising it in Ranch LLC. According to them, the Psycho Chihuahua was a smart and feisty Chihuahua dog with a big attitude. And this is what Ed Alfaro liked about the idea. He came to Taco Bell, and as you can see on the last picture, the phrase the famous phrase that the Chihuahua Taco Bell use is "Yo quiero Taco Bell," or "I want Taco Bell." Some of the terminology that we learned in this class, business law, is implied in fact contract is a legally binding agreement between two parties, and this is when a written contract is not present. Also, the misappropriation is an unauthorized or unlawful use of funds or other property for purpose other than for which it was intended. The conversion is a type of tort that exposes you to liability for damages in a civil lawsuit. Unfair competition is any unlawful, unfair, or fraudulent business act or practice, or false, deceptive, or misleading advertising. And some of these definitions were derived from Google website. The main case facts. Okay, so Taco Bell employee Fed Alfaro did attend the trade show. This is where he met the two men from Ranch LLC, and they started talking about the Psycho Chihuahua idea. Now, Taco Bell's employee did not accept or reject the proposal, but then he asked the plaintiff to create a marketing proposal, but it was never given. Defendant then hired another marketing agency, which gave a similar idea than the Psycho Chihuahua. And Taco Bell, knowing that the Psycho Chihuahua idea existed from Ranch LLC, they still accepted this idea from the second marketing company. Now, the issue here is, did Taco Bell violate the Copyright Act? Yes. And the reason is because there was a mutual agreement between the two parties. Also, as I previously explained, Taco Bell did know about the idea of the Psycho Chihuahua, and they still accepted the final proposal from Bennett and Williams. The verdict in this case was very surprising, because even though this was not the first time that Ranch LLC had sued Taco Bell, the first time they did it was in 1998, but the judge, he dismissed the case. In 2003, the judge Quist granted $30 million plus 12 million in interest. And even though Taco Bell tried to pawn off those 42 million to TBWA, the advertising company, the court rejected their motion to appeal. On the next two slides, you will find the references as well as the YouTube link. Thank you very much.